Well, hi, everybody. I'm going to go ahead and kick it off here and make an introduction to the fabulous Tamara Powell here. And then I think we'll have agents continuing to jump on. Thank you for being right on time. I am Annie Tyler, sales executive at Fidelity National Title. I see some folks who know me, some who may not. And I have brought my long-term friend and expert attorney, Tamara Powell, founding partner of Strategy Law, to talk to you folks. She primarily focuses on business related matters, real estate investment matters, and more. She'll tell you more about herself. But let's go ahead and jump in. She has a fabulous presentation for us today. I know some of you have been anxiously awaiting. So Tamara, would you like to go ahead and tell us a little bit more about you and then jump in and tell us a bunch of things we do not yet know?
Sure. We'll get started. So first of all, let me thank Annie Tyler and Fidelity National Title for inviting me to speak today. And thank you to Keller Williams. I particularly adore Keller Williams because my brother is an agent down in Orange County. So if you're wanted to share any deals down in Orange County, look up Bram Klein. But I am an attorney. I've been doing business and real estate transactional law, meaning I don't go to court, for almost 30 years here in San Jose. And my background's a little different than most lawyers because I also have an MBA and a real estate broker's license, which really helps me come at deals from the business person's perspective. And so that's why I'm here, talk to you all about the legal stuff, but from the business perspective so that you can know what to do with your business and you can help your clients and protect them on the business side. I've been up in Northern California since I graduated, or actually since law school. I did law school and business school at UC Davis and fell in love with Northern Cal after going to UCLA for undergrad. And I founded about 10 years ago my law firm, which is Strategy Law. And I'll go ahead and share my screen so that you can see the name. And let's see, there we go. And we're going to talk about real estate and choice of entity, which really boils down to, as you know, from the title of the flyer that went out, LLCs and S-Corps. And I'm going to try to do this in a way that will help you both, like I said, in your business and what you want to do with your real estate, as well as just sounding that much smarter and being that much more helpful to your clients. My understanding from Annie is this has been a very casual kind of interactive type process in the past. So if you have a question, feel free to either raise your hand through Zoom or go ahead and unmute yourself and ask. And as long as it doesn't slow us down too much, we'll go ahead and answer as we can. And if not, we'll also reserve some time at the end. So happy to answer those questions as you have them.
Perfect. Thank you, Tamara.
Okay, so let's see. California entity choices. I'm focusing today on California because that's where we are all doing business. So there are, let's see, 6 different types of entities that we can form here in California. You may have heard of others from other states, but these are the ones that are allowed under the California Corporations Code. Essentially, we'll go through these today so that you understand just what is out there. So I don't skip straight to S-Corp or LLC, and then you hear about one of these other types of entities later and think, well, why can't I do that? Or what's the downside? So I'm going to kind of go through those somewhat quickly, and then we'll focus really on the S-Corps and the LLCs towards the end. So let's see, sole proprietorship, general partnership, limited partnership, limited liability company. So that's one of my pet peeves. Don't call it a limited liability corporation. It's not. Those are corporations, and LLCs are 2 different things. So it's a limited liability company. There's also a limited liability partnership, which is different than a limited partnership. And then there's a corporation, which can make a tax election to be an S-Corp. So a basic corporation is a C-Corp, or you can do a tax election and it becomes an S-Corp. Either way, it's still a California corporation. first thought, it's amazing how often I actually turn people away and say you don't really need to form an entity. People don't generally understand what the entity can and cannot do for them to protect them from liability. So, and one thing I do want to remind you of is that a trust wasn't on that list of entities. So if you want to put a trust in place, and I think almost everybody should have a trust in place, that is going to make your assets go where you want when you die. That may save you taxes when you die, and it can create all sorts of other benefits. Trusts are generally not business entities in California. There are some Delaware statutory trusts that people use for 1031 exchanges, but in California, we don't have statutory trusts like that. And so trusts are essentially for estate planning purposes as opposed to business. So if you don't form an entity and you're doing business, it's really just you as the sole proprietorship. What does that mean? Well, the one reason I turn people away very often and say you don't need an entity is because an entity cannot protect you from your own liabilities. So for example, I'll use my own practice as an example. If I do something negligent in practicing law and I mess up, no entity around me is going to protect me from my own wrongs. The client is going to come after my law firm, and they're going to come after me individually for that malpractice. So just because I formed a corporation or some other form of entity around me to protect me from liability doesn't mean it's going to protect me from my own wrongs. Now, in the real estate side, that means, if you're out there managing the real estate yourself and you do something negligent, for example, you decide, electrical work really isn't that hard, I can do that, and you don't do it well, and you should have had a licensed electrician do that work, and it causes a fire. I don't care that you have your rental property in an LLC or your business in a corporation, whatever it is. If you're the one who negligently did electrical work without a license, they're still going to hold you individually responsible for that. So another reason to have an entity might be that you have employees working for you. Now, if you're a broker and you have salespeople working for you, you're still responsible for supervising those salespeople. Just like if I have a paralegal or another associate attorney working for me, I'm still responsible for supervising them. So again, I could be held responsible for something that they do within reason, of course, if it's not something that I could not have predicted, or if I did adequately supervise. So if you don't have any employees, again, that may be another reason you just don't need an entity. And, I want you to keep in mind, no matter what, entities are great and they do provide this shield for liability, but you really want insurance first. You want errors and omissions insurance for whatever you're doing, whatever your area of practice is. And sometimes that insurance, that money that you would have spent on the entity is better spent on insurance. And I actually did deal with a real estate agent and broker recently who got a client into a large commercial deal, and it was a one-off. They don't normally do these deals. There were people who had just kind of picked up their license on the side of their other profession, and they did one deal and didn't have specific errors and omissions insurance for that deal, and ended up getting sued. And now it's a disaster for them because they're going to be held personally liable. Anyway, so insurance comes first. What are the reasons to form an entity? We talked about liability protection. Sometimes it's a lender requirement. If you're buying real estate and you're getting a loan on it, the lender often wants that real estate separated from all of your other assets for liability protection. It's what we call a single asset entity or a bankruptcy remote entity. So if you're getting a loan to buy some real estate, you definitely want to be talking to the lender about their requirements before you just go ahead and form some sort of entity, because they may say they insist on having the entity formed in a certain way or in a certain jurisdiction, and you need to be prepared for that so that you don't have to essentially redo things over. I've had that happen where another attorney jumped the gun and just went ahead and formed a California LLC. And this lender wanted a single asset bankruptcy remote Delaware entity. And so they fired that attorney and started over with me because she hadn't done the planning they wanted. Also, employer requirements. You see a lot of people, consultants, especially here in Silicon Valley, who will form a corporation for their consulting business because they're working for these large Silicon Valley companies, and those companies don't want to hire individuals because individuals could be considered employees, and they have to, keep in mind whether they're an employee or an independent contractor. Whereas if they're hiring a corporation, there's no question of that. A corporation can't be an employee. So they're clearly doing a contract with a corporation. So that's a reason for some people here in Silicon Valley to form entities. Partners. Whether you form an S corporation and you're doing a shareholder agreement, or you form an LLC or some other type of entity and you're doing an operating agreement, it gives you a reason to put an agreement in place between you and your partners, which is always smart. Frankly, even if you're co-owning property as tenants in common, you should have a tenants in common agreement in place, but people often forget to do that. Taxes. People used to come to me all the time and say they wanted to set up an LLC or an S corporation to save money on taxes. And the answer in the past was often, it's probably going to cost you more in tax and not less. And that's because having an entity doesn't make anything a business expense that it wasn't previously. Either something is an ordinary and necessary business expense that you can deduct, or it's not. Whether you do it through a business is not enough to make that determination. However, in recent years, we have something new in California called the pass-through entity elective tax, which actually will save you tax money. And I am going to go through that later so that you guys can see where one of the benefits is in forming either S-Corps or LLCs. And there's also some retirement plans that you can do in an entity that you can't do individually. Finally, assist with succession planning. You'll often see family LLCs being used to transfer real estate to the next generation. And there are some benefits there because you can transfer an interest in an LLC and have it valued a lot lower than a direct interest in the property. And that gives you the ability to save on gift taxes. So for example, if you have $1 million building and you want to give it to your 2 kids, that would cost you $1 million as a gift. Gift taxes on that could be as high as $550,000 if you don't have any funds left in your lifetime exclusion. If, on the other hand, you instead put that into an LLC and give them interests in your LLC, now we get discounts for lack of marketability and lack of control in that LLC because they're not getting property, they're getting an interest in an entity which has these restrictions. And therefore the IRS says that $1 million building might now be worth more like $600,000 because it's locked up. So that's another reason we often see these family LLCs that own real estate. Finally, we mentioned planning for life events. Really, trusts come in there as well as entities. And I want you to remember that forming an entity in California is never a good way to get anonymity. California requires you to report at the very least who the managers are and what the business address is for that corporation or LLC. And there are a few ways around that, but in general, they do get that information from you. And now going forward, there's one other brand new law that I'm going to bring up and kind of teach you about today. It's the new Corporate Transparency Act. And I think that's really important for everyone to know, because if you already have an entity or if you're thinking of forming one, the Corporate Transparency Act is likely to affect you. Okay, so I kind of want to do some of this background before we get into kind of comparing S-Corps and LLCs, because the pass-through entity elective tax may be something that you've heard of, may not be, but it's very valuable in California because a few years back, we got this restriction that our state taxes are only deductible up to $10,000 a year. And most homeowners in California have that much just in property taxes. So the pass-through entity elective tax is a way that we can use pass-through entities to get an additional California tax benefit So what we do is we have that pass-through entity, and I should explain what that means, actually, sorry. Some entities like C corporations are their own entity that for tax paying purposes. So they're their own taxpayer. Other entities like S corporations and LLCs, which I can go through in a little more detail shortly, don't pay federal income tax themselves. They just split it up and have the partners pay that income tax. And that's what we call a pass-through entity. So we'll go through that a little more detail. But in California, the tax rate is as high as 9.3%. What the pass-through entity elective tax does is it says we're going to have the entity pay the tax on behalf of the taxpayer. So for example, my law firm can pay up to 9.3% of my qualified net income to California. And that becomes a deduction on the federal tax return, not the California return, but it reduces my adjusted gross income on my federal tax return. And then it gets added back to my California return, but with a credit for the taxes paid by the law firm. So in that case, what I'm really doing is getting a workaround. So instead of being limited to $10,000 of deduction for the property taxes on my home and not getting any deduction for the state taxes I have to pay on my income, now I can get a deduction for that income tax side in exchange for doing this pass-through entity tax payment and using it as a credit. So it's kind of confusing, but what you need to know is that if you want to take advantage of this, you need to have a qualified entity. It can be an S corporation, a partnership, an LLC that has more than one partner, and we'll talk about what that means. So it can't be a disregarded LLC or a disregarded entity for tax purposes. And it can't be a publicly traded partnership. It has to be doing business here in California. And the partners of that pass-through entity have to be either individuals, trusts, or estates. If they are partnerships that are partners of this partnership or this LLC, then those higher level entities have to use this credit instead of doing it at this level. So it's important because the first year you form a new entity, you don't have an immediate deadline. You can just pay this credit through the original tax deadline. Now, that means not the extended tax deadline. But in future years, by June 15th, you have to pay at least half of last year's amount or a minimum of $1,000. So you have to pay the greater of 50% of last year or 1,000, and there's no exceptions there. So it becomes this June 15th requirement to check in with your business accountant and make sure, or your personal accountant, and make sure you decide whether or not to make this election. And then once it's made, it's irrevocable. Out-of-state entities don't get to take advantage of this unless they're actually registered here in California, doing business in California. So this becomes a tax reason that we haven't had before, as of just starting in 2021, and it's good till 2025. It'll probably either be extended or that $10,000 cap in California will be changed, because most states have now adopted something similar to this. And it's a workaround to the Trump Tax Act that said we only get $10,000 deductions for our state taxes, which just doesn't work well for people in high state tax areas like us. So that's a new, relatively new law. And that is one tax benefit that I'm seeing a lot of real estate brokers and real estate sales agents come to me to form a corporation, an S corporation, purely to be able to run their commission checks through. So it doesn't even have to be a licensed brokerage, but they're saying, my accountant told me I need a corporation. It's got to be a pass-through. So I need an S-Corp. I want all my commission checks to get assigned to that S corporation so that going forward, I can prepay this California tax and get a credit on my federal return. And therefore I get much higher deductions and I pay much less tax. And so people are doing that even without regard to a licensed real estate corporation, just purely a place to take your commissions. Okay. And with that, I want to talk about the other new law so that I make sure I get these in. The Corporate Transparency Act is so new that it's not even in place yet. It actually becomes effective in January. But what it affects is all small businesses, essentially. And starting in January of 2024, corporations, LLCs, limited partnerships, any entity that files for formation with the Secretary of State has to file with FinCEN, the Federal Crimes Enforcement Network, a statement through their portal telling them who the company's beneficial owners are, meaning people who own 25% or more of the company, and who the company applicants are. So if I form a corporation for you, I'm the company applicant. If I direct my paralegal to form, then she and I are both the company applicants. And so there's now a lot more liability for who's behind these entities. And the point is to essentially prevent money laundering and terrorist funds in the US. We want to know where the money is coming from, who owns it in the US. And this is how FinCEN is doing it. You will have to provide not just, and I will have to provide not just my name, my residence, my date of birth. I will also have to provide a copy of either my driver's license or my passport, actually a copy with the photo on it. And I have to keep it up to date. So for example, if my driver's license expires, I need to remember to go back to the FinCEN website, which the portal isn't even open yet. But starting in January, I would need to go back there and provide them the new document. And this is critical because if you don't do that within 30 days, if you don't file within 30 days of forming the entity, or within 30 days of a change in who the beneficial owners are, or updating your documents, there's a fine of $500 a day. And it's up to $10,000 or 2 years in jail. So it's crazy how high the fine can be for this. And this is only, by the way, for active entities. So if you have somebody that never really shut down their entity, they should really get rid of it. But they're not going to go after ones that can prove they haven't done business in years. And by the way, there's also a new law in California as of this year that makes shutting down inactive entities a lot easier. And I think this is part of what they saw coming, is that we need to be able to close those out. So don't ignore your entity when you're not using it anymore, shut it down. You definitely want to make sure that you're not going to be subject to these fines. And the worst part about it is these fines and all of these requirements only apply to small businesses. If you're publicly held, or if you've got $5 million in revenue and 20 or more employees, it doesn't apply to you. The government seems to think that they have or will get the information on those publicly held companies. But what this is really doing is placing a huge burden on small business owners. So if you set up an S-Corp, or if you own a corporation or an LLC or even a limited partnership, you need to know as of January that this is the law and you're going to have to comply with it. Okay, with that in mind, general partnership doesn't have to be filed with the Secretary of State. And so if you don't file with the Secretary of State, you wouldn't be subject to the Corporate Transparency Act. I want just to remind everybody of what a general partnership looks like. If Annie and I go down to the corner and set up a lemonade stand, we are now in business together for profit, and we're a partnership, which means if we have more than $600 in revenue, we have to file a tax return. It means that not only are we sharing profits, we're sharing liability. So when you're in a general partnership, you are responsible for the liabilities of all of the partners. And that's you, and all of your other assets can be dragged into any lawsuit or liability. So you have to be very careful when you do business with others. You want to make sure you have a partnership agreement because there's no liability protection. And again, don't forget about insurance. So in the old days, prior to the late 90s in California, that meant you formed either a corporation or a limited partnership. The problem with the limited partnership is it still has to have somebody who's the general partner. And that means that general partner has unlimited liability for anything that goes wrong in that entity. That general partner also has control. So you want to put a partnership agreement in place. There's no liability. We talked about this for the general partner. And you're paying California $800 a year for the benefit of doing business in our great state. So what usually happens if you see limited partnerships today is it's a combination of two entities, an LLC that acts as the general partner, and then the limited partnership that owns the property. And sometimes that can be a benefit because then you're paying a little bit less in franchise taxes because the limited partnership only pays $800 and the general partner, if we form an LLC or a corporation to be that general partner, only pays tax on its small percentage of ownership of that entity. But you don't see limited partnerships that much anymore because it's just so much easier in many respects to just form an LLC to hold the real estate. One more type of entity, just so that you know about it, limited liability partnerships. If you take a look at my logo in the bottom right-hand corner, my firm is a limited liability partnership. That means that we're actually formed under the general partnership code of the portion of the corporation's code, but the LLP allows limited liability amongst partners for certain types of professions. Law firms, CPAs, architects, and land surveyors. That's it. When LLCs were formed, they are limited in the type of business they can provide. And so these lobbying groups got together and said, well, then we want our own type of entity that can protect us from our partners' wrongs. So going back to the example of my law firm, if I do something wrong, I'm responsible, and so is the firm, because you hired the firm to be your legal counsel. But my partners are not individually liable because they've got this LLP protection, which is different than general partnership protection. So that's just an aside so that you understand it's an LLP, different than a limited partnership. It's a limited liability partnership, and it's only available to these types of professions. Okay, sorry, there we go. So then there's the standard C corporation. You know, living here in Silicon Valley, we see a lot of C corporations. What's great about them, they give you the liability protection that you want. You know, that if you buy shares in Apple Computer and Apple does something wrong, you as a shareholder are not going to be held personally liable in any way for the liabilities of the corporation. Now, for small corporations, and this goes for S-Corps as well, you need to keep in mind that you get that liability protection only if you treat the company correctly. You must treat that corporation different than you yourself personally. So you don't want to commingle funds, and you want to make sure you follow all of the required formalities. You know, an example of that is I had a client once who owned a business, and they were essentially in the landscaping business, and they used a lot of their landscaping tools and people to do landscaping at their home and their other properties, the real estate that they owned. And they didn't charge those other properties. It was all just considered part and parcel of, you know, they owned the business. That's considered commingling. If you use company resources to pay for your individual items, a court can come back and say, well, you treated that corporation as the same as your personal pocketbook, so we will too when a liability comes up. So that's where you want to be careful with not commingling to keep that liability protection. You also have to follow the formalities. That means corporations every year have to have meetings, and they have to do things according to the corporation's code. So whether you're a C corporation or you've made that tax election to be treated as an S corporation, you have to follow the rules. that means annual meetings and minutes as to what happened at those meetings. So I want to step back for a second, and this comes up all of the time in closings as well. So I was working just this morning on a corporation where corporation owns some real estate, which is unfortunate, but that's how they've held it for decades, and wants to sell the real estate. And we had to clean up all of the corporation management in order to have the right authority in place before the title company would accept signatures on behalf of the corporation. So the way corporations are managed is there's 3 different levels. There are the shareholders who own the corporation. They own the company, they own the shares. Every year, those shareholders are supposed to meet, or they can act by unanimous written consent, and they elect who's going to be on the board of directors. So you get to vote as a shareholder to say who you want to be a director of your company. The board of directors runs the strategic level of the corporation. So any big strategic decisions, like a sale of all of the real estate in the corporation, needs to be approved by the board. Now, once you have a board in place each year, that board also has to meet every year at minimum. And the board appoints officers of the company to run the company for day to day. We will talk when we get to licensed real estate corporations that in a licensed real estate corporation, you have to have a broker officer. That's how you get the corporation licensed. So that's the 3 levels. You've got the shareholders who elect the board and the board who appoints the officers. When you're a shareholder, you vote based on your number of shares. When you're a board member, you vote based on the number of people on the board. And then the officers run the day-to-day based on the strategic level of oversight by the board. So that's how management works. And the managers need to have minutes of their meetings. In smaller companies, we usually want a shareholder agreement as well. So if you're going to own a corporation, a portion of a corporation, you don't want to just be subject to the default corporations code rules. You want to be able to put certain things in place to deal with your co-owners. For example, what happens if somebody dies? What happens if they're just not active in the business anymore? Do you want to have the right to buy them out, or do their shares just automatically go to the next generation, wherever they leave it in their will? Those are all choices that you can make and set up in a shareholder agreement. And I've seen all sorts of corporations have issues because they didn't put a shareholder agreement in place. So years ago, I had a company come to me. They were setting up a new business, and they needed help with forms for their clients to sign on to use their services. And I told them, you really need to have a shareholder agreement as well. There's 2 owners, you're 50-50. And they said, agreed, absolutely. We just don't have the money right now. Get us the form, we'll get the clients, we'll start building the business, and we'll come back to you to do a shareholder agreement. Unfortunately, this year, they never had gotten back to me to do the shareholder agreement, and one of them died. Now, the other became a co-owner with the widow, and the widow was not the friend they started the business with, and all sorts of problem arose. And because they didn't have a shareholder agreement in place, they didn't have any rights to buy out that widow. So you continue to build the business, she continues to collect half of it, even though she's not working in it. It becomes problematic. So anytime you become a co-owner with someone else in a business, whether it's a corporation, S-Corp, C-Corp, or we'll talk about LLC agreements too, you want an agreement as to all of these things that could happen. And in a corporation, we call that a shareholder agreement. For a C corporation, you can have both common stock and preferred stock, which we all know living here in Silicon Valley. An S-Corp is a little bit more limited. You can only have one class of ownership. And the downside, and the reason why we don't all use C corporations, is because essentially they're what we call double taxed, which means every dollar that Apple Computer makes, it pays tax on. to the extent, it doesn't have deductions for this. And then if it were to declare a dividend and give money out to the shareholders, you as a shareholder would pay tax on the money you receive as a dividend. So that same dollar essentially got taxed twice before you got to use it. In a large company, that might make sense, but in a small company, that's just painful. There are some ways around it, and that is by bonusing yourself a whole bunch of money at the end of the year. So some people like doing C corporations, and then at the end of the year, they give themselves a big bonus so that the company really has no net income at the end of the year because it gave it all out to them or their employees. That creates some issues because there's self-employment tax, or there are employment taxes on those wages. So that's where the S-Corp benefit comes in. We can not have to deal with that 2 levels of taxation. Plus, as we mentioned, now you also get that pass-through entity elective tax because the S corporation is a pass-through entity. So the S corporation only has 1 level of tax. The corporation itself does not pay taxes except for California franchise taxes for, again, the beauty of working in our state. Essentially, it has the same background, everything else that we just talked about in corporations, but it makes a tax election to be taxed as a pass-through entity. S, by the way, if you want to remember it, just initially stood for small. It was a small corporation, and because it's small, the IRS was comfortable with, instead of making the corporation pay the taxes, we're okay dealing with this small number of shareholders and having those shareholders pay the tax. Just to look through these again, liability protection, still you want E&O insurance, errors and omissions. This liability protection is not a substitute for that. It's essentially like putting up a firewall between what happens in your business and your other personal assets. But you always still want insurance to pay a liability so that you don't lose your business if something happens. And if you're going to be a director or an officer and there are other shareholders, you probably want to consider director and officer insurance as well as errors and omissions insurance. We talked about S corporations can only have 1 class of ownership, and they get pass-through taxation, which means they're taxed on gains, not distributions. So it doesn't matter how much money the corporation gave you each year. What matters is how much profit the corporation made. So if you leave all the money in the company, it doesn't keep you from paying tax on it. It's your share of the company's profits that you pay tax on each year. Now, S corporations are generally not favored in owning real estate. They're definitely used for brokerages, and they're definitely used for those commission receipts. Excuse me. But we don't like holding real property in them for multiple reasons. There are limits on who can be an owner of an S-Corp. You can't have any foreign owners, and certain types of trusts can't be an owner because this is supposed to be a small, simple corporation. So if something happens, for example, one of your shareholders dies and leaves shares to a foreign relative, or somebody puts it into a trust that isn't an S-Corp eligible trust, any one of those things can essentially wreck your S election, which puts you back to being a C corporation with that double taxation. Nobody wants to pay double tax when you sell real estate. That's a ridiculous amount of tax to pay for no reason. But even worse than that, even if you don't become a C corporation because somebody messed up your S election, S corporations, will compare them to LLCs shortly, but their tax treatment of real estate when it comes out is not as good as it is for LLCs. So there can be taxes when you take real estate out of a corporation, which are different than the way LLCs treat them. So we'll get to that in a minute. Okay, LLCs, limited liability companies. Like I talked about LLPs before being limited to certain types of businesses, LLCs are limited to certain types of businesses as well. They cannot do professional services, and they can't be a real estate broker. So limited liability companies, if a business requires a license under the Business and Professions Code, it cannot be an LLC unless that Business and Professions Code clearly states that it can. So initially that meant nobody with a license under the B&P code could be an LLC. Years later, some contractors, for instance, started updating their codes to allow for it. So you can't do a real estate brokerage in an LLC. One of the things, by the way, also you can't do is it can't be a bank or certain types of investment companies. And the interesting thing is when you're naming your company, this is a total aside, but when you're naming your company, whether it's an LLC, a corporation, anything that you register with the Secretary of State or do business under, you also need to keep in mind trademark issues and Secretary of State issues. And so naming your company, you really should get some advice and make sure that you're not stepping on anyone else's toes. A totally ridiculous example of this LLC types of business restriction. Years ago, over 20 years ago, I formed an LLC for the Left Bank restaurant. And I tried to file with the Secretary of State for the Left Bank LLC. And Secretary of State kicked it back and said, nope, banks can't be LLCs. And it was ridiculous. I tried to explain that the Left Bank was not a bank. It was a geographical place and it was a restaurant, and they wouldn't have it. So in that case, we actually ended up filing the same name in French. So La Rive Gauche LLC ended up owning that restaurant purely because the Secretary of State wouldn't allow a bank to be an LLC. So sounds stupid, but keep it in mind when you're naming your entities that there's all sorts of considerations. And I can go and talk about that for ages because I've seen so many people step in it and have to change the name of their company years later after they've spent a bunch of time and money. Licensed real estate corporations, people generally just name after themselves, and there is not that much creativity. So wanted to just kind of walk through what it takes and what a licensed real estate corporation means. You don't need to be a licensed real estate corporation if you just want to take advantage of that pass-through entity tax and form an entity to collect your commissions. You're essentially just assigning your commissions to that corporation. Doesn't have to be licensed. But if you're going to be doing any real estate licensed activities in your corporation, it must be licensed, and you must have a licensed person as an officer. So corporation may be licensed as a real estate broker, an LLC may not. The broker must be what we call the designated officer, and that person has to supervise and control all the activities requiring a license that happen in that corporation. You can assign some supervision to another licensed broker officer if you have board consent of the board of directors. Excuse me. But you have to keep in mind, one thing you cannot do is say, I'll be the broker officer for this company, and then step back and not actually do the supervision, because you will be held personally liable for failing to supervise. Okay, so what does it look like to form a real estate corporation? Step one, you complete a licensing application. You have to tell them who the broker officer is. Step two, you have to keep in mind that for any director or officer with responsibility for corporate policy, or anyone who owns more than 10% of the shares, you will have to file a corporation background statement if there's anything to report within the last 10 years. So if they've had their license revoked or suspended, or if they've been convicted of a crime or anything like that, they may not be allowed to be the licensed broker for your corporation. And then finally, step three, you pay the fees. You get your live scan fingerprints, etc., And these fees are per licensed broker in the corporation. Little different if you're a mortgage loan origination corporation, you need to register with the mortgage licensing system and get an endorsement for your corporate broker license for the mortgage side. Okay. You could be just a partnership. If a couple of brokers wanted to do business together, they could just form a general partnership. I don't recommend it because you're subject to each other's liabilities, but you cannot be an LLC. So generally, as we've talked about, since LLCs can't do this, but they do provide this great liability protection shield, we use them to buy real estate. They're fabulous for putting a complex agreement in place that says who gets what. Excuse me. They are very flexible. You can have different owners have different types of stock or membership interest or units or whatever you want to call them in the LLC. So I represent a bunch of real estate developers that have different classes of membership interest. They'll have their sponsor interest that they get, based on a waterfall after all of the investors have gotten their money out. They might have different classes of investor getting different rates of return based on when they invested. Lots of flexibility we can build into the LLC agreement. Now, if it's a smaller LLC, and that's what I'll focus on for the moment, if you or your client want to put an LLC in place because you're buying some real estate, what do you need to know about that? First of all, you still need an LLC agreement, even if it's just one of you. It's not considered fully formed unless you have an agreement. And so you don't want to take that risk because the whole reason you're forming the LLC is for liability protection. So you do need an LLC agreement, even if there's only one member in the LLC. We generally don't do a lot of single member LLCs if we can help it now, because if you have 2 or more members, it's considered a pass-through entity, and then you can get that pass-through entity elective tax credit. So interestingly, in LLCs, and in California, husband and wife hold property generally as community property. I can form an LLC where I'm the sole owner, or I can form an LLC with my husband in our trust, and that trust can be the sole owner, or I can form an LLC with my husband where we're each 50% owners, or we're each 50% owners as trustee of our trust. And it all still flows the same way. So there are benefits now to saying, look, husband and wife are going to act as 2 owners, because then we get the advantage of that pass-through entity elective tax. Doesn't always matter in real estate because there's a lot of losses. So if you have a ton of losses thanks to depreciation, there may not be any income that you need that pass-through entity elective tax credit to use against. But you may want to consider making it a partnership prior to a sale so that you can take advantage of it at that point. The downside to making it a partnership is essentially that you have to do a separate tax return. So I'm kind of going out of order here, but there are 2 things that you need to think about when you decide to do an LLC. 1, is it single member or multiple member? And 2, do I want it to be managed by the members, or do I want it to be managed by managers? Now, you'll hear that title and you'll see it a lot in escrows, because generally the manager signs on behalf of an LLC, just like an officer does for a corporation. So the manager is what we call the officer in the LLC. But again, I told you earlier, LLCs are really flexible entities. So if you want to have officers, if you want to call yourself CEO or president of your LLC, perfectly fine. We just build it into your operating agreement. Absent that, you're either a manager or a member. One of the terms that I don't like is managing member, because I think that confuses people a lot. So if you're a manager, it's different than a member. If you happen to be both, great, but I don't like using managing member, because to me, that makes it unclear whether it's member managed and you're one of those members, or it's manager managed and you're a manager who happens to also be a member. So I try to always keep those separate. one of the reasons this is important is if you have an LLC, you will file an annual statement of information with the Secretary of State that lists either the members, if it's a member managed entity, or if it's a manager managed entity, that statement of information that you file online lists the managers. And we see people do this wrong all the time. And this does come into play when you have a closing. And I just got a request today from a title company saying, I don't see that the right authority, or who has the right authority to sign here, because it's different in what they filed online and what the agreement says. So I'm going to need you to do, these unanimous written consents, and we're going to have to update the Secretary of State. So it's good to get it right up front for multiple reasons. It could also create some issues with liability and with commingling if you don't really understand what your entity says and you're not treating it appropriately. So you can choose if you're managed by the members or if you're managed by managers. If you're managed by managers, it makes life really simple because you can sign on the deed as manager of the LLC, for instance. You can sign on the lease as manager of the LLC. Whereas if I own an LLC for real estate and I'm going to hold that in my trust, and now I'm signing as the member, it's going to be Tamara Powell as trustee of the Powell Revocable Trust, dated whatever, every time I sign a document. So it's much cleaner to just say Tamara Powell, manager for this LLC. And you always do want to sign in that name. So if your property is owned in an LLC, you need to make sure that that LLC is the person signing the leases, signing the deeds, signing the contracts, not the individual. All right, let's get back to tax for a minute. S corporations are taxed differently than LLCs, but both of them have to pay this $800 a year minimum tax to California. I didn't actually go through the S-Corp one, but maybe I will on the next slide. S corporations pay 1.5% of their net income, no less than $800. LLCs don't pay this franchise tax based on net income. They pay based on gross revenue, gross receipts, but it's this step amount. So the slide shows that I pay $800 a year minimum plus a gross receipts fee, and it's not cumulative. It's one of these. So if my annual rents on my rental property in an LLC are $200,000 a year, that's my gross receipts for that entity, I'm only going to pay the $800. If I hit $250,000 in gross receipts, I'm going to pay the $800 plus the $900. And if I hit $1 million in gross receipts, I'm going to pay the $800 plus the $6,000. So it's not cumulative. It's just one of those things. Now, if you've got over $5 million of receipts in your LLC, hopefully that's a great thing and you're happy to pay the $11,790 plus the $800. But you may want to consider at year end holding some of that income so that it's on either side of the calendar year if it could trigger an increase. So for example, if you're at $4,999,000, you're going to pay $6,000 in gross receipts fee. As soon as you hit 5 million even, it's gonna almost double. So it's a year-end planning thing. But that's how we tax LLCs, and that's how they're different than corporations. Okay, a little comparison here. S-Corp versus LLC. S-Corps, again, can be a licensed real estate brokerage. You don't get tax basis if you guarantee a loan. That's one of the reasons we don't put real estate in the S corporation, because of that. It's very complicated, but that's what I was referring to as far as not tax advantageous. They pay $800 minimum tax plus 1.5% of net income. You can't have any foreign shareholders. Only certain revocable trusts are allowed to be shareholders. You can only have one class of shares, and you have to pay yourself wages in an S-Corp. You would get a W-2 so if you set up a brokerage corporation, you would then pay yourself a reasonable comp as a W-2 employee, And then the rest you could take as profits that wouldn't be subject to self-employment tax. On the other hand, an LLC, you can't do professional services. You can't be a real estate brokerage. And they're preferred for real estate investments because of the tax advantageous nature. If you take out a loan or if you guarantee a loan, you get tax basis in that loan when you're an LLC. And so all of that goes against your profits when you sell the building. And it's really easy to pull buildings in and out of LLCs. You pay $800 minimum tax plus the annual fee we just talked about, but it's very flexible with regards to who the members and the managers are. And the members are not employees. So if you're in an LLC, you're not able to get a W-2 because as an owner, you're not an employee. It's different. Only have a couple of minutes here, so I'm just going to skip really quickly through the next two jurisdiction. I hear all of the time, well, how about if I just form it in Delaware or Nevada and then I don't have to pay these California taxes? That was the case prior to about 2006, 2007. When the recession hit, California started tracking all of this. The law is if you're here in California or your property's here in California, you're going to have to pay California taxes. There are still some reasons to form in Delaware or other states. It could be lender requirements. It could be other liabilities. There's some liability advantageous treatment for certain states. And you can always form in another state, but then you would have to register in California. So certainly something to consider before you start. And then finally, I'll just end with a quick story. You know, how many LLCs do you want? Do you want a different LLC for every piece of real estate you own? It depends. Some clients like to group based on geography. Some like to group based on how much equity they're willing to risk. I like to think of it as dominoes. If you put all of your dominoes close together and there's a liability, meaning one domino falls over, anything that's in that LLC can fall too. So you want to place your dominoes into separate LLCs if you're very concerned about losing any of them. Just to kind of explain a lot of the concepts I mentioned today, years ago, I had a client who owned 8 different homes in Santa Cruz. One of those homes backed up into an alley. They paid a contractor to tile an upstairs bathroom. At the end of the day, the contractor was tired. He had an empty wooden crate that the tiles had come in, and he figured it'll save him a trip down the stairs if he just drops that empty wooden crate out the back window into the alley so that it can land near his truck and he'll pick it up afterwards. He drops the wooden crate out the back window. Right at that moment, somebody steps out from under the building and gets a wooden crate on the head. She was seriously injured, but thankfully they were able to settle for the maximum insurance amount, which was $1 million, and she didn't die. But the clients essentially freaked out and realized that they could have been held responsible for that as the owner of the property and the person who hired the contractor. Sure, they could have sued the contractor, but you know, he was probably almost judgment proof, so there's nothing to get there. So in the end, they decided to take all 8 of their properties and put them into 8 separate LLCs because it was worth $800 a year times 8 to them to have each one protected because they saw how quickly a liability could happen and they could lose everything. I thought that was overkill, but it's whatever helps you sleep at night. So it's a personal decision as to when you feel you need more than one entity. Unless, of course, I started out at the very beginning saying if you have large properties and you have a loan, the lender may simply dictate what they want. So we're at 3 o'clock. Nobody's asked any questions. I'll be happy to stick around for a couple of minutes if anyone has questions. Or you can take note of my email address or my phone number. You're welcome to reach out. I'm always happy to just have a short introductory call with you or a client about any deal you're thinking about getting into to see if there's anything that you should be aware of or anything I can help you plan for.
Okay, I see one person asked for your contact information, but that's on the last slide. And I know your time is valuable tomorrow and it's 3 o'clock. But if there's any urgent questions, oh, looks like Deepak has his hand up. How about you, my friend?
Thank you, Annie, for organizing this, and thank you, Tamra, for going over this information. It's a lot of information, very useful. I noted down some points, but I'm sure I might have missed some just because there was so much information. But thank you for organizing this session. I actually have a few questions. Not sure if we have enough time, but basically, first I wanted to ask you, because I'm an investor myself, along with being a realtor, do you help with qualifying somebody for a real estate professional status?
That's a tax decision and often left to whoever's signing your tax return, because there's a test to make sure that you're doing real estate more than you're doing anything else. Likely, if that's what you do in your day job, you can qualify.
Okay, but that's something we should talk with our tax expert.
Yeah, whoever's signing your tax return has to agree that you are a real estate professional, so that you don't have passive losses. They can be used against your ordinary income as ordinary losses.
Okay. Now, as a relatively new agent, when do you suggest is a good time to start thinking about forming an entity? Like, is there a certain business size or volume? Because I've heard conflicting opinions from different people. Some say, S-Corp is the way to go. That's the best for solo agents. Some say, no, you could just do it on a 1099, and beyond a certain volume size, then you should start thinking about liabilities and stuff.
Yeah, as an agent, you're supervised by a broker, and you have insurance, hopefully under that broker, that will cover you from liabilities. So it's not so much that it's going to protect you from liabilities as it is, a helpful way to take advantage of retirement planning and that pass-through entity elective tax and other planning through the entity. If you're getting employees, then I would consider doing it. Anytime you're working with employees in California, you're just frankly in danger because we're a very employee-friendly state.
Right. But then can you contribute towards your tax, towards your retirement without forming an entity?
You can, they're just different choices. So you can do
like a solo
self-employed IRA, things like that. Whereas once you have a company, those choices broaden.
Do you recommend doing the real estate business as a realtor and your real estate investments as part of the same entity?
No, I keep real estate investments separate as much as possible. For multiple reasons. We're in a litigious society, and I wouldn't want those two things mixed together if I can help it.
Okay. I have two more quick questions if there's time.
That's up to you, Tamara. Is that okay?
Yeah, that's fine. And nobody else is stopping you. So as long as they're happy to listen, that's fine with me.
Awesome. Thank you. Can you also form a C-Corp and draft a shareholder agreement for investment properties as well?
I would never put investment property into a C corporation because it's going to be double taxed when it comes out someday.
Got it. Okay.
So there's nothing illegal about that. It's just not a good tax move.
Okay. Got it.
And as a matter of fact, if you find corporations that own real estate, you want to try to switch those corporations to an S-Corp if you can. So at least you get pass-through tax as opposed to double tax.
But LLC is the best way to go.
Yes.
As far as, and then you have like a buy and sell agreement between the partners?
Exactly. It's built into the LLC operating agreement normally.
Okay, awesome. Thank you. That's it for now. Thank you so much.
I think there was one more question in the chat, which you sort of may have already answered. Is it okay to use LLC to receive realtor commissions?
That's a good question. I believe so, because it's not doing anything licensed. It's simply receiving the commissions, but most people don't. Everybody forms an S corporation for that, because that way, if you wanted to continue to use it later as a licensed corporation, you could. So we generally don't see anyone putting that into an LLC. Also, the main reason you want to do a corporation for those commissions is because we can then take some of that income and make it salary, and the rest is just profit that you don't pay employment taxes on. Whereas in an LLC, the whole thing is subject to self-employment tax. So the S corporation gives you better taxes.
I have a quick question. So if I want to set up a one-on-one meeting with you, how do you charge?
That's a great question. So, for an initial, you call me with a question, I don't charge. If you hire me to assist with the legal work, we do charge hourly because we, except in some limited circumstances where we know exactly how much it should cost, it's usually unpredictable. My rate's the highest at $6.50 an hour. I have associate attorneys, including, I was telling Annie on the way in, I've got a real estate associate that works for me that used to be a residential agent. He does most of our residential deals. He bills at $4.20 an hour, and then we have a paralegal that bills at, I believe, $3.20 or $3.30 an hour, that can help with most of the formation work. So I come in to do the strategic level stuff, tell them what I want, and usually review it afterwards. But we push the work down to whatever rate can handle the project.
Okay, thank you.
Well, thank you. I think we all got a lot of free legal advice today, so that's very gracious of you, Tamara. Thank you very kindly for your expert education and answering some informative questions for us.
Thanks. Hope it wasn't too much of a fire hose.
Well, it gives everyone something to think about, and they can call you and engage you if they need further help.
All right.
Thank you,
you very
everybody.
much.
Thank you so much.
Thank you again,
Have a great
Tamara.
day.
Bye now.